All right, welcome everyone. We are going to get started, so come on in and have a seat. Welcome. This is Ethics and Technology, Not What You Can't Do. So thank you all for being here. I'm Hannah Kaufman from the Lawyers Trust Fund, Council for Innovation and Technology, and I am delighted to be here with these two fantastic panelists to have a discussion that is sorely needed. So we talk a lot about technology, and we talk a lot about the ethical implications of using technology as lawyers, and which kinds of duties are important for us to know about, what the ethical implications are of some of the technologies that we are interested in using or already are using. But we don't always talk about it in terms of what you can do. We talk a lot about the very risk-averse nature of lawyers drives us all to talk mostly about what we can't do. So we really wanted to have a different kind of conversation today and instead discuss not only the challenges and the questions and the concerns that we need to be aware of, but also what we can actually do, which safeguards need to be in place so that we can work with the times. So I'm really happy to be here. We have two wonderful panelists. I'll introduce them both as they come up. But first up, we have Sari Montgomery. And Sari is counsel to the Robinson Law Group. She focuses her practice on professional responsibility, consulting, and lawyer discipline defense before the ARDC. She has a long and decorated history as a real specialist in legal ethics. And now does consulting work with organizations focused on legal technology as well. So you can read her bio on the event app where all of our slides are also located. We'll begin with the first slide deck, and Sari, without further ado, please come on up. Thank you.
Hello everyone, I'm very glad to be here today. And I really was excited about the approach to for this presentation, not about what you can't do, because so often that's what we talk about, what you can't do in ethics. But really with technology, it's so exciting because it's kind of a new frontier. So there aren't a lot of rules about what you can't do. And in fact, the rules that there are really about what you can do in technology, which is kind of a shift in perspective for us in the ethics field. So what I'd like to get started with, what we're going to do here is kind of do an overview of some of the rules that are implicated in the use of technology in legal profession, and kind of trace how it's developed so that it really is a positive, the rules really have been a positive influence on the use of technology. So in 2012, the American Bar Association Ethics 2020 Commission came out with some recommended rule amendments related to technology, and they really encouraged the scope or the use of technology in conjunction with limited scope representation. And I know have been some other panels that have talked about limited scope, so we're not going to really go into it too much here. But the use of technology really dovetails nicely with limited scope representation. The more that consumers and clients can use technology and online platforms, the easier it will be for lawyers to engage in the limited scope representation. So, as I'm sure you all know, technology can really make your practice more efficient, and it can enable you to provide services to more clients. So the use of technology in the legal practice is not new. This is a concept that the profession's been dealing with since the 1990s with the advent of email and fax machines. And if any of you have teenage children, you know that they don't even use email anymore. They've moved beyond email. So it really kind of shows the trends of technology and how fast it really moves. So back in the 90s, using email and fax was a new frontier, and people didn't know whether you could do it safely and, was it okay. So at that time, the ABA again took the lead, issued a formal opinion and said, yes, it's okay to use email, even though there are some risks associated with it that we aren't used to really dealing with. So that was sort of the first foray into how regulators were going to look at the use of technology in the profession. And I think it's really important to note that the ethics rules really don't impose any greater obligations on you when you are using technology than what you would have normally in your practice. You still have the duty of confidentiality, you have a duty of competence. They're all the same fundamental duties. It's just sometimes you have to take certain steps or precautions in order to use them in compliance with those duties. So we're going to have a quick overview of which rules apply. First, Rule 1.1, and most of these rules have been updated recently in Illinois specifically to mirror the changes that happened with the ABA model rules back in 2012. The Illinois Supreme Court adopted many of those changes in 2016. So we're going to go through a brief overview and then we'll talk a little bit more specifically about each one. So Rule 1.1 talks about competence. And there's a new comment, 8, which was adopted in 2016, which specifically incorporates the concept of technology into the definition of lawyer competence for the first time. So in order to be competent now, not only do you have to know about technology, but you really almost have to use technology now in order to be competent. Rule 1.2, scope of representation. Again, that's talking about limited scope representation, and we're not going to talk about that too much here because it's a little bit beyond the scope. And then Rule 1.6, and this is kind of where the meat of the changes are. Section E was adopted in 2016, and that's the rule that requires lawyers to make reasonable efforts to prevent unauthorized disclosure of client information. So that raises a lot of questions. So what are reasonable efforts? And we'll talk about some guidance that's been given along those lines, both in the comments of the rules and in some ethics opinions. Another topic that touches on the use of technology is the use of non-lawyer assistants, and that's not a typo, it's assistants with the CE, not assistants with the TS. That is how the rule is phrased, and there are a couple of different aspects to that. One is the use of outside service providers, because everybody now, with the advent of cloud storage and things like that, nobody has all that in their office. You have to outsource it. And how do we do that and comply with our ethical duties? So that's one facet of it. We also have to look at the unauthorized practice of law, and I know that's often a big concern with the use of technology. It's come up in many contexts. But it's important to note that under Rule 5.5, it's okay for lawyers to use non-lawyer assistants, TS, not CE, to assist them in performing their law-related tasks, so long as they're properly trained and supervised. So that's okay. There are many practice areas where non-lawyers do the bulk of the day-to-day work, but are supervised by lawyers, and lawyers have set out the training for them and the step-by-step guide on what they're supposed to do. For instance, in immigration, it's sort of a decision tree sort of process where non-lawyers can, fill in the blanks, so to speak, as long as they're being supervised by a lawyer and, are following the directions of the lawyer. So those are the main rules that we're going to talk about. Let's talk a little bit more in depth about competence. So competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And in the new comment that was added in 2016, comment 8, it specifically incorporates the concept of knowing the benefits and risks associated with relevant technology into the definition of competent representation. And I would suggest that that this knowing the benefits and risks associated with relevant technology would apply to whatever relevant technology is applicable in your specific field of practice. It's not just knowing what, it's not just knowing email or whatever platform you happen to use in your office, but it's also being aware in the environment of what other technologies are available and whether it's beneficial to your clients or not, and weighing the benefits and risks of using those technologies. So now it's not only can you use technology, but you really almost have to use technology under the rules, or at least consider using it. Again, this all came about through the Commission on Ethics 2020 through the American Bar Association, and this was the first time that there was an explicit reference in the rules to having to be knowledgeable about technology, relevant technology. You don't have to know everything, you just have to know what's relevant to your practice. Confidentiality. This is really the tricky one. So, again, a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. So, what are reasonable efforts? Reasonable efforts are not impenetrable efforts. You don't have to have 18 layers of security for, in the majority of the representation that lawyers engage in. I won't say never, but for the most part, that's not going to be required for reasonable efforts. The comment 18 to this rule talks about what reasonable efforts are, and we'll get to that in a minute. But it's important to note that we hear about inadvertent disclosures and hacks of data every day. There was one last night, Equifax, right? They got hacked. Law firms get hacked too. It's not that uncommon. DLA Piper was the most recent firm that got hacked, large-scale firm that got hacked over the summer. And there are a number of reports that have come out recently which talk about how often there have been data breaches in law firms, and they really range anywhere from 15% of lawyers reporting that they've had data breaches in an ABA survey, a 2016 ABA survey, to Altman-Wiles survey, which said 1/3 reported data breaches. Then there was a LogicForce report over the summer, which reported that 2/3 of firms have had some sort of data breach. So hard to know which of those numbers are accurate, but I think it's the takeaway is that data breaches can happen, but that is not enough reason to not use technology. It's a reason to take precautions, okay? So we're not going to, DLA Piper didn't wake up the day after their data breach and say, okay, we're not going to use technology anymore, we're going to go back to paper, right? What they did was they went back and examined all their systems and figured out better ways to try to protect their data. And this is something that's obviously evolving. The more firms use technology, the protection of that data is evolving as well. So I think it was pretty forward-thinking of the ABA and the courts that have adopted this rule to take that into consideration, that it doesn't have to be perfect, and we're not going to discipline lawyers if there's an inadvertent data breach, as long as they've taken reasonable measures. Okay, so what are reasonable efforts? It really depends on the particular type of representation. And the factors that Comment 18 talks about really, I think, give a lot of context. So, you need to look at the sensitivity of the information that you are handling, the likelihood of disclosure if additional safeguards are not employed, the cost of employing additional safeguards, difficulty of implementing the safeguards, and the extent to which the safeguards themselves can adversely affect your ability to represent your clients. So let's talk a minute about sensitivity of information. Now, I'm assuming that no one in this room is protecting, the nuclear codes or the, designs to our missile defense system or anything like that. So I think it's safe to say that you don't need to have an eye scan to access the data that you need for your work. And I don't mean to demean or diminish the type of information that you hold on behalf of your clients, but we're talking about what is reasonable. So, and Terry will talk a little bit more about the context of this. Many of your clients have already given up a lot of the right to privacy to a lot of their information, which doesn't mean that you don't still have to protect it, but it certainly adds to the context of it. Is a password reasonable? Yeah, I think most people would say having a password and having, basic encryption functions is reasonable. But do you have to have 3 levels of security to get into your system? Again, you need to look at the sensitivity of the information and, again, what is the likelihood of disclosure if you don't employ really high-level safeguards? What type of information are you holding on behalf of your clients? So thinking about the context of the audience here, you're servicing legal aid clients, which sort of by definition don't have a lot of assets or money. So what is the likelihood that hackers are going to be targeting your databases to mine your clients' information? Maybe not quite as much as Chase Bank or DLA Piper. So, that's another thing to take into consideration. So I think that reasonable really means reasonable. Sorry, did you have a question?
Yeah, well, just what information do we as legal aid providers have? And what comes to mind? Obviously, the Social Security number,
Sure.
date of birth, and the name.
Sure.
So, and there might be some others that. I'm just thinking there should be a way for the legal aid community to kind of come to a consensus on, okay, these are the pieces of information that are most likely appealable to hackers, and what's the standard? Maybe you're going to get into more of the standard. I can see these factors, but you've got a specific community here, a legal aid community that is.
Right.
There's particular pieces of data that would be valuable to outside hackers.
Correct. To some degree, I agree that is definitely information that needs to be safeguarded. It's personal identifying information that can be used for fraud and other purposes, and you do need to take reasonable safeguards to protect that. And I think that Terry will get into a little bit of how that information is sort of segregated when people interact with, for instance, the Aleo platform, so that it's not accessible to the providers unless and until they take on an attorney-client relationship. The rules don't specify what specific measures you have to take. It's going to have to be done on a case-by-case basis, and they did that deliberately so that the rules could be broadly applied to any practice area and any client profile, so to speak. And it really is going to require you to make a judgment call and determination of what steps are appropriate for your particular clientele. And I know that's not a very satisfying answer to your question, but I can't give you a checklist. I can't tell you, yes, you need a password, no, you don't need a fingerprint, or how many layers of protection that you need. And the reason for that also is because it changes. It changes on a daily, weekly, monthly basis what protections are available out there. So if the courts were to come out with a rule that says, if you service this type of client, you have to have this type of protection, that could change, the next week. So, unfortunately, I can't give you a definitive answer on what you specifically have to do to safeguard the information, except to the extent that I think that you have a good resource pool amongst yourselves to talk about what your colleagues do and what resources are available at reasonable cost to accomplish safeguarding the material.
I just want to point out that I think that in addition to specific types of information, it's also important to think about the information in a relative context. So social security numbers are usually information people identify as being pretty personal, names and addresses. Mm-hmm. But just a zip code could be identifying in a certain circumstance if it's given out with other information, such as a legal problem code, being domestic violence, and the zip code being the only zip code in an entire county where domestic violence cases taking place.
And
so
more, right.
The relative context of the information is important too.
And more broadly, which is more broadly than the scope of this presentation, Rule 1.6 requires that you maintain confidentiality of any information relating to the representation, down to the zip code, down to whatever it is. The point of the technology aspect of it is how do you accomplish that? And what measures do you need to take to accomplish that using technology? So it doesn't change the fundamental requirement of Rule 1.6 that you protect every piece of information, including the fact of the representation itself is required to be protected under Rule 1.6. The issue is what measures do you have to take using technology to accomplish that. So you're absolutely right. There may also be some other situations and factors that require additional steps to be taken to safeguard information, and that's kind of beyond the scope of this presentation because it's very specific, but an example of that is HIPAA. So if you're handling information protected by HIPAA, there may very well be additional safeguards that you need to take, especially in dealing with outside vendors in technology, in order to ensure that information, the protection of that information is compliant with HIPAA. So just be aware that there may be other considerations. Okay, so the ABA has issued a formal opinion, and I have inserted a link to that opinion last May, which gives a lot of guidance. And again, they specifically decided not to put in a checklist or specific measures you needed to take because the technology is changing so fast. But it really explains in greater detail than I can here, the fact-specific approach to implementing security measures, commensurate with the risks involved. And you can also check out the ABA Cybersecurity Handbook, and that might also have some more specific guidance as to how the degree to which you have to safeguard specific types of information and how to do so using technology. The ISBA actually sort of beat the ABA to the punch in this one. In 2016, the ISBA issued an advisory opinion which specifically addressed the permissibility of cloud computing, and that was sort of a big issue in the legal profession, moving from an on-site, having all your information on an on-site server, so it was completely under your control, to putting everything in the cloud. And some practitioners felt like putting everything in the cloud, you're really completely giving up control over the information, and how can we possibly do that ethically and still, adequately protect our clients. The horse has really left the barn on cloud computing. I think the vast majority, or many legal providers use cloud computing now. It's just become unmanageable to maintain the volume of data that you need to on an on-site server in most cases. The analogy that I like to use is that the risk of storing information in the cloud is really no greater than the risk of storing confidential or client information in paper in your office. Before we kept everything electronically, you would have files. Well, there's nothing to say that someone couldn't break into your office and steal your files, right? So yes, there is a risk that people can hack into information in the cloud, although I would argue that most providers have such a high degree of security that it's much less likely that it's going to be broken into in the cloud than somebody breaking into your office. But the point is that there is a risk, but it's not that much greater a risk or greater at all than how we used to maintain confidentiality. Is a reasonable measure in maintaining confidentiality of paper files to lock your office door when you leave? Sure, that's a reasonable measure. In the same way you think about the information in the cloud, is it reasonable to have a password to protect that information? So, it's not a completely different concept that we're dealing with. It's just looking at it in a different way. Okay. We're running a little bit short on time, and I don't want to get into Terry's time. So, well, I don't want to interfere with Terry because she has prettier slides. But using non-lawyer assistance, again, you have to make reasonable efforts to make sure that the outside providers that you're using are complying with your professional obligations. And comment 3 talks about the due diligence you need to do in selecting a provider. And the ISBA opinion that I cited earlier also gives some guidance on what to ask your provider and what to look for to make sure that the provider that you're using is going to live up to your obligations as a lawyer. So, you want to review the industry standards, investigate whether that provider has had, what protections they use, whether they've had breaches before. If they have, what have they done in response? So that type of investigation. You also want to make sure that all of your data is appropriately backed up in a way that's under your control, so that if something were to happen with the provider, you would still have access to your data. And if for some reason the provider goes out of business, you want to have a way, make sure that you have a way to retrieve that information. So you want to make sure that that's in part of your agreement, and also that you have that mechanism available. Again, with unauthorized practice, I know this is something that often comes up. The rules don't prohibit lawyers from using the services of non-lawyers. You just have to make sure that it's done in a supervised way, and that the lawyer ultimately retains responsibility for their work. The lawyer is allowed to give professional advice to non-lawyer staff, claims adjusters, employees of financial or commercial institutions, social workers. So lawyers can assist those non-lawyer professionals in their work as well. And if you look at comment 3 to Rule 5.5, it talks about that. And finally, I'm going to wrap up with talking a little bit about some of the specific platforms, and Terry's going to get into much more detail on this, but we all know there have been a lot of emerging technology and platforms that have come up that your clients and our clients can use to interact with you online, and sort of triage services. So before they get to you, they interact using these platforms, and they provide their information to sort of, again, in a decision tree model, get them the information that they need and to the right resources. This is a constantly evolving subject, and so there aren't a lot of rules around it yet, although there have been a few cases which have dealt with whether or not these types of platforms, where the client is inputting information and getting information back as to what their next steps should be, whether or not that is appropriate or acceptable. The most notable case is cited here, the Legalzoom versus North Carolina Bars case, where the Legalzoom sued the North Carolina Bar because North Carolina did not like Legalzoom providing online forms and online legal advice. And there was actually a U.S. Supreme Court opinion relating to dentists, and North Carolina trying to regulate dentists who were trying to stop non-dentists from teeth whitening procedures. I know it seems off topic, but it really ties into the legal regulation aspect of it. And basically what the Supreme Court said is that the state cannot regulate functions which aren't actually the practice of law. So in the same way that, or what they said in the dental case was that the state can't regulate, things that aren't the practice of dentistry, and what North Carolina and Legalzoom took from that was lawyers can't, the state can't regulate what non-lawyers do that does not constitute the practice of law. And what Legalzoom was saying is, we're not practicing law. We are giving people forms and information that they can use to represent themselves. We may all have different opinions on the value of that, but needless to say, it's out there. 5-10 years ago, you could walk into any bookstore and buy a form book, or you could look up the forms that you wanted to, if you wanted to do your own will, or you wanted to, do your own divorce. You could buy a book that would tell you how to do it. And really, these online platforms like Legalzoom are really not that different. It's really client, the user-driven, consumer-driven, to use those services. Now, Legalzoom in North Carolina entered into a consent decree. The case was not fully litigated, but their consent decree basically said that a couple of things that were notable. North Carolina said, okay, we won't interfere with you doing this, but you have to make sure that the lawyers are the ones who are drafting the documents and are making sure that what you're putting out there for consumers is accurate and appropriate. So it had to be lawyer-driven. And they also said that there had to be disclaimers, that this was not legal advice and that you should seek the advice of a lawyer. So those were two requirements. But they also both agreed, interestingly enough, to promote legislation which would permit these types of consumer platforms to allow people to have more access to legal information online. So these types of platforms are here to stay. I could talk for an hour about AVO and all of that, but that's kind of a different topic. So the types of platforms that Terry is going to talk about really are becoming more and more generally accepted in the legal community. One quick word about chatbots and artificial intelligence. It's real. That's the newest of the new. Okay, even newer than than these other platforms. The case that everybody talks about is the guy in England who created a do not pay, where he created a mechanism by which people could fight parking tickets using this automated system. And it was kind of brilliant because lawyers didn't want to do that kind of work, and yet it allowed people access to that sort of service. So there's so much potential with chatbots and AI. The ABA reported that 70% of people surveyed would rather interact online with a chatbot than with a live person. So take that, lawyers. I'm not sure what that says about lawyers, but I think the article actually said that the driving force was just the immediacy of being able to get the answers to what you were looking for. But clearly there is a market for this, and there will be companies that are going to fill that market, and it's coming. And we really just need to again figure out how our profession can accommodate it, because I don't think anyone from the regulatory side believes that it's going to be stopped. Thank you.
Thank you so much, Sari. And I'm very happy to see that there's audience involvement, and we're definitely going to have more time for that. So, continue to raise hands if you have questions. But we'll also have a discussion section after this. But first, I am here to introduce our next speaker, Terry Ross. Many of you may know her. She is the program director at ILEO, Illinois Legal Aid Online, And we're very happy to have her here. While Sari was able to provide her expertise in terms of how the rules of professional conduct interact with technology and all of the ethical case law, Terry's really here to talk from the legal aid perspective about her rich expertise in the practical application of those ethical questions when using technology to serve legal aid clients. So without further ado, Terry, come on up.
Yeah, slides would help.
So really, I'm not an expert on anything. let me just get that out there. I only practiced for 2 years. I practiced at Prairie State. Some of the people who I reported to are in the room. I'm curious who some of you are. I see many familiar faces, but how many of you are dealing directly with clients on a day-to-day basis? Most of you in the room. Okay. Great. All right. So you guys have much more experience than I do. I'm just going to talk for a few minutes on confidentiality versus privacy, which is a very interesting intersection and one that gets muddied, I think, frequently. I'm also going to talk about some practices for security for us to be able to take those reasonable efforts to make sure that we're maintaining confidentiality. So let's get started. So again, we're going to look at these themes. When you start looking at confidentiality, privacy, security, there's a lot of dichotomies that arise. And I just want to get us thinking about them. I don't have any great answers, but I want to get us thinking about them. So what Sari presented on were our professional obligations as lawyers. And those sometimes inform our core values, and sometimes our core values are separate from them. But I want us to think about the difference as who we are as professionals, what we're obligated to do as professionals, and who we are as people, and what values we have. And I also want you to think about the values of the people that you are serving and how they may be different than your own. So privacy is I think, a very good example of this, right? So what differences are there between confidentiality and privacy? Anybody have any ideas? Are they different? Nothing? You didn't know that this was going to be an interactive session. So privacy is rooted in common law, right? Confidentiality is an ethic. That is part of our ethical obligation. So privacy, comes from Old England, right? When we talk about property rights, and confidentiality is our ethical duty. So privacy, to some extent, has ownership implications, right? And so when we talk about confidentiality, it's important for us to keep in mind the idea of disclosure and consent. But when we talk about privacy, our privacy rights are our own, right? The professional ethics rules don't talk about privacy; they talk about confidentiality. And so when somebody else gives us the data, information, whatever it is, we are obligated to keep it secure. But when it is not ours, or if it is only ours, it's up to our own to decide what we do with it, right? And so our clients and the people that we serve are frequently receiving public benefits. What's the price of admission for gaining the public benefit? So I think there are many, right? So they get a benefit, but they also pay a price to get it. And one of the prices they pay is they sacrifice their privacy. Right? So you have, many of you raised your hands. Give me some examples of when a client, because they receive a public benefit, has to sacrifice their privacy. Right, so reporting income, routine inspections on a house, right? What else? Yeah. Medical records for Social Security, absolutely, and that's very, very, very private information, right? Any other examples? So, I mean, when I started working at Prairie State, I was shocked. The Public Housing Authority in the county, one of the public housing authorities in the county that I worked in, I guess, I was just naive, right? I was a new attorney. But I was shocked at the fact that somebody, if their husband left them, if their son got arrested, if they lost their job, they had to report that to the Public Housing Authority within 5 days of it happening. And how undignified that seems to be, right, to us. And one of the Public Housing Authority had a private investigator on its staff, who would make sure that things were being complied with, these kinds of rules are being complied with. But so I want us to think about how our values of privacy are different from the people that we seek to serve. And why there is a value in sharing your information. The academics call this social capital. So there's actually some papers that are that academics have written about this. But the idea is that you get a benefit from sharing your information, and depending on how openly you share it, your benefit varies, right? But there is social capital that people gain from doing this. And so I think that in simple terms, it's, social capital is a good academic term, but it's really support and attention, right, that people are getting from. And so we as lawyers are frequently worried about how our clients, what our clients do with their information, right, and how they use technology and other things, right, that could harm them. But there are reasons why they do it, and I think it's important for us to keep that in mind. My heart on your sleeve. So again, remember that we as lawyers, when somebody else is sharing the information with us, we are more obligated to that information and to the client than they are to it, right? They can do with it what they want because it's theirs, but we have a very strict obligation, right? The other thing I think that is important to keep in mind here is that almost none of our clients or the people we serve know what confidentiality is, right? And so we need to explain it to them in no uncertain terms and keep reiterating what our obligations are. And so that's really important. I think that it's also important to note that the idea of privacy is very different depending on the environment you live in, the culture you live in, where you were raised, what values you have, and so on. And I think that these things are really important to keep in mind. I linked out to a couple of studies if you're interested in seeing what some of those cultural differences are. And there's a lot of information on this. So let's switch a little bit for a moment to talk about security. So when we are the stewards of somebody else's information, how can we keep it secure? So hopefully you all have better systems than this one, right? This guy's sleepy. Is this from a Seinfeld episode? I think that's maybe. Yeah. So it's important. I think the most important thing to look at is the universe of the data that you keep. And not just you as a single attorney in your office, but also as your organization, right? Because we all keep, the client information is very obvious, right, based on our rules of professional responsibility. But we also hold a lot of other information in our if you think about on an organizational level, what are some of those, what kinds of information do we hold as an organization? Yeah.
Employee information.
HR. That is some serious data, right? Any other examples? I think that's the biggest one. The other one would be sort of your financial, any financial data, I think is really common. For law firms, I think trademarks, copyrights, those kinds of things are also at issue. But so I think that it's important when you think about the universe of data that you not just think about your obligations towards confidentiality to your client, but also your obligations to the employees and the other people, your colleagues, right? So you want to get an idea of of the universe of your data, who has access to it, and at what level, right? So that goes to something called permissions, right? So we all know probably from our case management system that some people can view some things and some people can view them, but they can't they can't tinker with them, right? And some people can't do anything, right? So these are all things that we want to keep in mind and you can take advantage of, and technology enables us to be able to do that, right? To say, okay, well, I can release this report view, but I'm not going to allow this set of people to actually be able to just view the report and not to alter it, right? Or they can only view a certain part of the report, right, or a set of data. And this also goes to Vivian's point earlier about the context of the information, right? So one piece of data may have no meaning in and of itself, but when you overlay it with other pieces of data, it starts to have a lot more meaning, right? And being cautious about what that is. So this is a common security practice. Does anybody know what a firewall is? It's kind of a strange name for what it is. Can anybody give me a definition? Vivian, do you want me to call on you?
I'm not an IT person.
Neither am I. I was hoping there was an IT person in here. Is there an IT person in here? Oh, Jerry.
Firewalls is just a simple definition, device that controls entry onto and out of a network.
Right. So it's like a screen door, right? I think that's a good analogy. It allows the air to pass through, but it doesn't allow the bugs to pass through, right? And you can set it to whatever.
I like to use the traffic cop.
The traffic cop. Okay, there you go.
It's essentially asking for the doorman to ask us, are you supposed to be coming in or are you supposed to be going out?
Right.
They ask every little piece of data that comes in.
Right. And so that is both the firewall protects both incoming, right, and outgoing. So if you think of your personal network, your organization's network, and how data is transferred in and out. Thanks, Jerry. And there's, on all of these next slides, I have some links in there. If you want more information, I've just linked out to a resource, but there's tons of stuff online if you are interested in learning more. So the next one is encryption. So encryption gets thrown around a lot. We all hear about encryption on a daily basis. Do you guys know what it actually is? It's been around, I discovered when I was preparing for this presentation. It's been around for thousands of years. And this is a cipher and a key of, so Julius Caesar used to encrypt his battle messages. And so it's a particular way of encoding something so that somebody, if it's intercepted, can't tell what it actually says unless they have the key, right? And so that's encryption is typically used these days to talk about the transfer of information through some technology channel, right? So if you think about It's most commonly used as in the email example because email is so insecure that if you're putting any kind of personal information, it's always best to encrypt it, and you want to encrypt it end to end, right? And so that's from the point that it leaves all the way to the point that it's received. Because if it's not encrypted end to end, then it can be intercepted along the way. Although I did see an email, a news article yesterday about law firms whose internal controls people are being flummoxed by encryption because they can no longer tell whether people are complying with the internal controls because of the encryption. I don't think that's an issue with legal aid folks, but so redundancy. So this is essentially making a backup, right? Just making sure that somebody else knows how to do your job, right? Somebody else, there's another system in place. There's an alternate generator that switches on when the first one fails. So this is just making sure that you have backup systems. And all of those things are really important because no doubt at some point something's going to fail, right? And so we need to have technology in place to accommodate, mitigate that. I hope everyone in the room has antivirus software on every device they use. There's really good antivirus software out there. There's a lot of different kinds of it. It is, in my opinion, incompetent not to, in my opinion, which doesn't mean anything, is incompetent not to have antiviral software on the devices you use. That makes them a lot more vulnerable. So make sure you're doing it. Also, exercise good judgment. Yes, Rich?
I know this is a stupid question, but if you have an excellent firewall, why do you need to have good antivirus program?
Yeah, so he's pointing at you, Jerry. Do you want to answer?
Computers, like here at McCormick Place, you don't really know the quality and the safety of the firewalls at this building. So if you were to take your laptop here and connect to a public Wi-Fi, you could potentially get something. Or most likely it's second-degree user error. So even though somebody emailed you a virus, you didn't know what it was, you actually allowed it into your computer, and you gave your authorization to bring it.
So this is called phishing, right? Phishing with a PH. And I think that is really common. And that goes to this third thing I have in gray. This is good judgment, right? Be aware that there are a lot of these kinds of phishing scams where it looks, and some of them are very good, right? It looks like an actual notice from Chase Bank. And you click on it, and wham, now you've downloaded something onto your computer, and if your computer is networked, it's now affected every other computer on the network. So really be aware that those scams exist. Keep your eye out for them. If you don't know who the sender is, you weren't expecting something from Chase Bank, don't click on the link, right? So.
You will never get a disciplinary email from the ARDC related to an investigation. So there actually was a phishing scam not long ago where the ARDC, it was claiming to be the ARDC, and people were very concerned. So it can happen to anywhere.
Yeah, Steve.
I'm a layperson, so I'm just relaying this as information that I did see on the tech website, what I believe is a reputable tech website, when they polled actual developers, software developers, or maybe it was even security IT, I'm probably misremembering, as to the steps that they took to protect their own systems. Using antivirus was not at the top of the list. What was at the top of the list was applying software updates.
Right. Yes, good point.
So
yes.
I cannot speak to whether that's true or not because I don't have a technical background, but it does contradict what I perceive to be the conventional wisdom among lay people about security.
Yeah. Well, and I think that that goes to the changing industry, right? So software developers have realized that they need to, based on consumer feedback, they need to update the vulnerabilities that are found and do it in an immediate way, right? And I think that's absolutely right. I mean, one of the software that needs to be constantly updated is the anti-virus software, and that does protect you. I think it's important to note you have to layer a lot of these things on each other. You can't just do one or another. You can't pick and choose, but they're all important. Yeah.
Along the same lines, what about ages of computers and how much that matters that you have an old machine?
Well, so the machine itself, the age of the machine doesn't matter. What matters is the software that runs on it, right? And once there are certain machines that can only run certain types of software, right? So I think eventually what happens is you can only upgrade your Mac laptop to a certain level, and then beyond that, you can't keep it up to date, right? And then at that point, it's time to retire it. I would say if it's no longer being supported, if the operating system is no longer being supported, then it's time to let it go. So passwords, we all love passwords. I have password fatigue every day. NIST, the National Institute of Standards and Technology. My brother-in-law works there. He's brilliant. He's a brilliant mathematician. They just came out with a set of standards for passwords, which are very different than the ones we're all used to, that we all have had to adapt. And so you can read about that there. I think the more important consideration with passwords is that you cannot use the same password all over the place. Because if one thing gets exposed, if one thing gets hacked in one place, then that makes you vulnerable in all the other places you've used it, right? And so Peter Campbell, who is the former Chief Information Officer at the Legal Services Corporation, has said that he has now, one of his top tips for IT and doing things safely and securely is to use a password manager. How many of you have used a password or are currently using the password manager? A few, right? So there's lots of them out there. Many of them are free, and it's important to do because again it keeps you less vulnerable. So that's all I have.
Thanks so much, Terry. So we've gotten a very rich overview from both of our presenters just now, both about the ethical obligations and then giving also some practical tips when we talk about reasonable safeguards and precautions that need to be taken, what those really look like, what some of the industry standards are, and best practices in legal aid. So I'm hoping, Rich, that gets to some of your questions about building a consensus among legal aid professionals. There's the seeds of that there, and lots of folks that we've already heard from in the room, Vivian included, have some expertise here as well. So we want to take a little bit of time now to discuss some examples. So these experts here are going to join us in talking through some hypotheticals here. So first, this isn't exactly a hypothetical, but we've touched on a couple of the data security concerns that people have when using new technology. But I'm wondering if, Sari or Terry, in your experience, people ever overlook the risks with sort of the existing ways of doing things. So what are some risks that people might not realize that they've already become comfortable with and accepted? I think that's probably, yeah. Go ahead.
Oh, go ahead. I was just going to say, I gave the example earlier of, an office being broken into and files being stolen. There are also kind of more common risks. For instance, You could have an employee in your office who is, accessing data improperly, both hard copy data or digital data. So that's another example. Having another risk that you have with physical, documents that you actually avoid almost entirely with the cloud is, the risk of flooding or fire or, natural disasters. I mean, I've had many clients who have, especially in recent years, have had floods in their offices, and they've lost a lot of their information and their client files, and it's very hard to recreate those things. So there are a lot of advantages to using digital solutions to keep all of your information safe. And I think that on balance, it probably the benefits outweigh the risks much more so than the older ways of keeping information.
Okay, thanks. Anything to add, Shula? Great. Yes, question.
I just wanted to share a comment that I've heard from clients and community members in general, and it's the risk that they have grown used to that we don't acknowledge. So I often hear, if you send me a letter, my neighbor can read it. So why can't you send me a text? If you send me a letter, somebody in my home can read it and find out my status about X thing. Why can't you send me an email? And I hear that and I don't have a response, right? I say I feel an ethical obligation to communicate in this format. But I think it's something to acknowledge. What are the risks that our client populations have grown accustomed to? And it's not just a matter of convenience. It's a real risk that they've acknowledged.
Absolutely. And so also thanks to everyone in the audience for both being engaged and also speaking very loudly. So I don't think we really need to repeat the questions. Raise your hand if I'm wrong about that. Okay, great. So to that point, yeah, exactly. So that gets at a little bit of what Terry was speaking about earlier about that tension between sort of how clients may view their own privacy and how that interacts with our ethical duties of confidentiality. But I think that's absolutely accurate that there certainly are very real risks with paper mailed items, and that can often be the default. I know that you have some feelings about email as well. Do you want to share them, Terry?
Yeah, so let's talk a little bit about. Can you guys hear me? Is this on? Yeah. Okay. So email is quite insecure, right? So you want to be very careful what you send over email. I think it's fine to say, hey, we have a court date, next week, don't forget to bring me those papers, right? Or here's how you should dress, or I'll meet you here, whatever. But I wouldn't include any information beyond that in an email unless it's encrypted. SMS is a little more secure as long as you are not using a voice over IP, like Google Voice. So if you're doing it through an actual provider, they have relatively good protections. So that adds a little more security for you. I know that LAF will soon be piloting an SMS text message service where they're going to connect legal server to SMS. So there are some case management systems that can connect to SMS, and I don't think it's all that. I think it's pretty cost effective to do it, and it saves the SMS in the case notes. So there's a lot of good reasons to do it. Many clients prefer SMS to other matters, such as mailed letters, right? Yes.
What specifically makes email less secure?
What
specifically? Like, what are the risks? Sort of, is it like a password problem? Is it a phishing problem? Like, what are sort of the...
So email is email that is not encrypted is just much more transparent as it travels through the ether. Okay. Right? I don't have a good. Is Jerry still here? He left. I drove him away. Yeah, Vivian.
So on email, one of the things that you can do to think about email is to think of it as a postcard as opposed to a letter. It's not sealed. So it really is open to anybody who cares to look at it. Whether what should I send to my clients via email, what should I not send to them? And this goes to Terry's point about good judgment. It really is a judgment call, always, because there is sometimes going to be instances where you need to send your client information, you need to get it to them, and they want you to send it to them via email. That's the most expeditious way to get it to them. Be careful about what you send. Don't put in information you don't need to put in, like a social security number. But if you need to say something about their case in order to get them that information, it might be the best way to do it via email. It is always going to be a judgment call. It's very hard to set up encryption in the true sense because you have to have the same encryption both ends. So your client would have to have encryption too. And that's really just not realistic. Our clients send us documents via email. We send them documents via email. The best thing to do is just every time you do it, think about whether there's a better way to do it that's efficient, that's going to get them the information and maybe protect it a little bit more than it would be protected via email. But I think from the standpoint of the work that we all do and all the clients that we represent, it's very hard to say, don't use email or use it very sparingly because even though there are risks, sometimes it's worth taking those risks in order to communicate with your client and advocate from that. The other thing I wanted to say is that, this whole concept of good judgment, it really becomes a business problem in terms of figuring out when something is a scam or a phishing expedition. And it's important for everyone to sort of stay abreast of what is going on out there with technology and with scamming. And just be cognizant, be careful. Be careful about what you open and click on every time you use your email. Text messaging is more secure. That's one reason we want to try it. And the only other thing I'll throw out there is that for all of us, with our own personal lives, there aren't the same protections on email that you have with mail. The wiretapping laws and the postal regulations don't apply to email. So if somebody did open your mail, they are violating the law. But you don't necessarily have that protection with email, nor do our clients.
And I think that this whole conversation raises a really important point. It kind of goes back to your duty of competence. It's an important conversation to have with your clients about how they want you to communicate with them, right? I mean, for instance, you may have a domestic violence client who doesn't want you to text them or doesn't want you to email them because perhaps their abusing spouse or partner has access to their phone or access to their email account. So you need to have that conversation with your client at the outset to find out how they would like you to communicate. Maybe they have a P.O. box they would rather you send a letter to. I think you really, again, it goes back to judgment. You have to look at what's going to be in the best interest of your client. And the other thing I would say is, we're talking about protection of information, not just the information that you have, but how that information is transmitted. And you can't necessarily control what's going to happen on the other end of that communication, right? You can only control it when you possess it, but once you put it out there, you can't control it. So that's why you have to, use judgment in the specific situation to determine what's going to be the most secure way to keep that information confidential. Do you have a question?
Yes.
I think we're missing at least one of the elephants in the room when it comes to email, and it's not so much email communications between attorney and client, because if you're a good counselor, as a general proposition, you can affect an understanding with your client as to what the risks associated with email are, and then adjust to their level of consent or their own level of being risk averse. What I see plenty of is, emails flying between opposing counsel containing draft agreements that contain all sorts of personal and extremely private information. And I don't know if there's a technological solution to that, because with email it takes two to tango, at least as I understand. For encrypted email it takes two to tango, as I understand it. So you need a level of cooperation from your opposing counsel that we're not used to, at least I'm not used to, if you're you're going to try and have an encrypted conversation. So I wonder if people could speak to that issue, not the attorney-client, but the attorney-attorney communications via email.
So it looks like Vivian has a response. So let's do that quickly, and then we're going to move on to just another example. Yeah.
This might be something that you would all say, but one idea when you're communicating with opposing counsel is to use a password-protected attachment. So if it's a Word document or an Excel document, put a password in it and then attach it to your email. Now remember, communicate the password through a different form, by telephone or text. If you communicate the password in email, that defeats the purpose of password-protecting a document, even if it's in a separate email. But that's one simple way to add.
Yeah, I can also suggest, there are lots of services out there that allow you to share documents like Dropbox and Box that are free to use, and you can share those with, share documents in that way as well by as long as the other person has a Box or Dropbox account set up, you can upload whatever your document is, and then they enter in their login and password, and then they can access it. And there are different levels of security, I believe, with those services as well. So there are ways to share documents other than strictly emailing them back and forth that are more secure.
And so we've talked a lot about security of data and how we transmit it to clients. And I think, Sarah, you were touching on the end about how what the client's preference is for how that information comes to be. And I think, Terry, your framework earlier really spoke to that sometimes the way that we approach business as usual is not necessarily exactly how the clients would prefer it to be. And as all of you know, certainly as well as we do, that comes up in the context of access to justice quite a bit. And when we try to serve the number of people, we're unable to meet that need for a wide variety of reasons. But some technology tools can be used to amplify the services that we can provide. So I want to share a hypothetical here. So a group of legal aid lawyers who specialize in divorce law are frustrated that because of funding limitations, they can generally not take on clients who are seeking just a basic divorce unless there's some kind of a complicating factor, such as the presence of intimate partner violence or something of that sort. So they work together to design a TurboTax-like flowchart of questions and answers that would guide someone without access to a lawyer through the process of filling out forms and getting information associated with getting a divorce. Technologists then implement this system and post it online for anyone in the public to use for free. The guided interview not only helps generate a form filing, but it also gives the user information about their rights, responsibilities, and what the procedural next steps are. So the question here is what, if any, are the ethical concerns, and should we be concerned about the unauthorized practice of law? Which safeguards can we put in place to help mitigate or address them?
I think this kind of goes back to the Legalzoom example that I spoke about earlier, and the key really is to make sure that you have a lawyer involved in setting up the system and the process to make sure that it's accurate and doesn't misguide. One key factor you want to always consider is, when you have things online, you're likely to have people from different states accessing it, and you need to make sure that that's taken into account so that if you have people from Indiana accessing specific documents or instructions, that you have an Indiana lawyer vet the process that's being put out to the public. And I would also say that I think it's really important for those platforms to have disclaimers as well, that they are not providing legal services, that they're, that people should seek legal advice if they want legal advice and not rely on these platforms as legal advice. But like Hannah said, we know there is an enormous need for self-help, so to speak, so that people can access the justice system that just can't afford it or for whatever reason are not eligible for the services that you all provide. So, there's this big gap that needs to be filled, and, the old saying that perfect is often the enemy of the good, it has a lot of application here, because this is at least gives people some help. May not be ideal, but it's better than nothing at all. And in many cases, it can be perfectly sufficient for their purposes. So I'm not trying to put lawyers out of business, but I think that there's a huge need that is not being met by our profession, and I don't know that there's anything in the foreseeable future that is going to meet that need, because people just can't afford legal services, and there aren't enough of you to provide them at a loss of cost.
Sure. So, and I think what you've said here about not letting the perfect be the enemy of the good is really the most important element here, and what keeps being codified and explained in the comments of all the rules. It's reasonable efforts. It's not impenetrable. All of that. And so I'm just wondering. We talk a lot about needing some of these expert systems that guide self-represented people. We need to make sure that they're perfect, and that's everybody's desire, which makes sense. And I'm just wondering if there are any circumstances where lawyer-provided services in person are not perfect either, but we're more comfortable with that because we're more in control of it. And so are there any examples of places where the technology might actually be able to provide advantages over a human lawyer?
I mean, I think that the importance of good screening is critical when these systems are being developed. And if you don't offer the screening, then you have to be transparent to the user about what the scope is, right? What situations does this expert system cover and what doesn't it? Ideally, it has the screening in it, and somebody doesn't have to sift through all that and figure it out for themselves. You just ask them questions. You say, are you in Indiana or aren't you? You're not? Okay, you can't use this interview, right? If there are certain very complicating factors, like you start thinking about what are the edge cases on a typical legal matter, and let's immediately try to identify those and divert the person to an attorney if we can, right? So I think that's critical. These systems have generally better usability than a standard paper form that you could get from a book, like Sari mentioned, which is what many people still do, because they're simpler to use. They ask one question at a time, so you're not overwhelmed with a bunch of questions, or a form that has a lot of blanks and really small type. I think that a good form interview is one that enables the use of plain language and readability, both in the actual words that it uses and in its design, so other people can use it easily. Not all of them are like that, but those are all the good qualities.
And just one other comment about people apparently having a preference for interacting online as opposed to coming in person. Not only the immediacy of the response that you get, but you don't have to make an appointment. You might be embarrassed by whatever your situation is, and by interacting online, you can maintain your anonymity, and I think it can also be intimidating to try to identify a particular lawyer who can help you. Especially if you're not familiar with the profession. Where do you go? Can be overwhelming, whereas if you're in the privacy of your own home and you have an internet connection, you can sort of vet that for yourself. So I think that it definitely offers some positive benefits as well. Not as good as having real legal advice, obviously, but again, it helps fill that gap.
Yeah, excellent. Thanks. Okay, so now let's do a twist on that. So we have the same situation, right? But now let's say that the same expert system that we just described is up and running, and it's successful. It has been vetted. right here by Sari. It is stamped approval for ethics compliance. And then the technology experts who helped design the system approached the legal aid lawyers to suggest that recent advances in artificial intelligence can allow systems like the one they've created to be improved through machine learning. So in this newly imagined model, users would not need to select from a pre-populated set of answers, but instead they could type in a free-form, natural language response to a question that's posed online. The system would be trained by looking at lots of data before releasing it to the public to determine the meaning of words and phrases that may make up user responses and to guide the user to appropriate resources, including and in particular lawyers, accordingly. Once the system went live, it would then be able to learn from user responses and interactions to improve its ability to provide relevant information based on the user's input. So what risks do we have here? What kind of oversight is necessary, and which safeguards do we need to put in place?
Just remind anybody of like Skynet. This, as I said before, is such a new frontier in the legal profession. It's very, very new, and I think that there isn't a lot of material out there about it because it is so new, but everything that I've seen has basically said, this is something that is in its infancy and is something we need to very closely monitor to make sure that as it evolves, that it is legally sound and that there's some quality control on it. I don't know how those two things are going to be implemented because it really is so new. It's not why this type of technology is not being used on a broad scale yet, but I think it's naive to think that it won't be. I mean, it's evolving in other areas, in other industries, and the medical industry is using AI. It's naive to think that it's not coming to law on a broad scale. So I hope and assume that the people who are working to bring it to the legal profession are making these considerations, to make sure that people aren't getting bad advice and that, the technology, that it won't be implemented until the technology is at a level that would be competent.
Great.
Yeah, I think it's important to note on this that the quality of the data is critical when you're developing these systems. So you probably are familiar with the term garbage in, garbage out, right? So your data has to be relatively pure for these kinds of systems to work well. And they do exist in the legal market space. There were a couple of sessions yesterday, the one that Andrew Baker and Dan Lena did in the afternoon, I don't know if anybody else was there, went through some of these systems. Ravel Law is one that has essentially taken all the court records in certain jurisdictions and can make a prediction on how the judge is going to rule in your case of whatever type it is. And that's a commercial product, and law firms are subscribing to it. And so the quality of the system is market driven, right? They need to have a really good high prediction rate, right, of success, right? And that drives them to ensure that the data is good and that the algorithm they're using is good. But these systems are definitely out there, and they're being more and more widely used.
So I think that actually concludes the hypothetical section. We have a couple of minutes left over for questions, and I would like to put this out there. Who haven't we heard from back in the corner?
Yeah, I have a question about, earlier you talked about, or one of you talked about, the client consent factor. And what about when they don't really have a choice as to how that is done? For example, in the situation of a bankruptcy, you have to upload these documents to a trustee's portal. That's how you have to do it. I mean, what do you do for that?
1.6 actually has a section that says that it's okay to disclose client information if it's implicitly needed for the representation, essentially. I'm paraphrasing, but obviously if somebody hires you for a bankruptcy, you can't represent them in the bankruptcy without uploading that information to the trustee. So that would be permissible under 1.6, a permissible disclosure of their confidential information. And one would hope that the trustee's portal is relatively secure.
Great. What other questions? Yes?
I'm thinking about, in the last session, we learned that consent without full disclosure is not consent. And if full disclosure about a client communicating with our office and back and forth is going to be by email, and we're not asking them as a matter of routine whether they have a password-protected Wi-Fi router. I mean, I live in a college neighborhood, for example, and when I go to my Wi-Fi, I can see unsecure Wi-Fi networks. And so I'm just wondering if we're doing enough, or what else we should do to inform the client about what they need to do. Like, we need like a checklist if we're going to really get full disclosure consent. So this is more of it's kind of a pregnant question I can see.
I think that that's part of the conversation that you have with your client at the outset, to say, usually the most efficient way for me to communicate with you is either by text, or I may need to email you some documents, but I want you to know that you should never email me your social security number, or you should never, we need something that you can have a checklist of particular information that you think is not appropriate to be emailing. So, if we need to exchange that type of information, I'll call you, or I'll, figure out some other method of transmitting it, or maybe you have a secure way to do it by email or Dropbox or something like that. But I think that, you're not going to be able to cover every scenario at the outset of the representation, but if you have some fairly basic things that you can tell every client, no client should be emailing you their social security number, that those are the types of things you can say at the outset.
Great. Any other questions? All right. Well, thank you so much for joining us, and thank you to our wonderful